Hi, everyone. I'm attorney Andrea Chavarria, and I am here today to go over certain questions that people have asked us about. I know that a lot of people have questions and concerns about what is going on in the immigration field. Um, One of the questions that we received is what are the most recent changes in U.S. immigration policy? And that's a really great question. It literally feels like every week we are receiving new information in terms of policy changes. And so immigration law itself generally hasn't changed that much because laws have to get passed through Congress. But the changes that we have seen are immigration policies, and that can be either with the Department of Justice, with the Department of Homeland Security, which under the Department of Homeland Security, we've got U.S. Citizenship and Immigration Services, we've got ICE, and Border Patrol. So there are some policies that have changed recently. And in fact, today there was news that the diversity visa lottery program has been canceled or has been paused for the time being. So I know everybody's getting fed a lot of information through the news. So it's important, especially if you're thinking about obtaining an immigration benefit or your loved one is seeking some sort of benefit, to discuss this with an immigration attorney and see how these policy changes could potentially affect you and your loved one. Now, one of the other big news or changes in policy that we have seen lately is the travel ban. So we know that there was a travel ban in effect, and additional countries have been added to this travel ban. And so in total right now, we're looking at 39 countries that are on this travel ban list. Some of the travel ban relates to full restrictions into the United States, and there are other countries that have a partial restriction. So again, if your loved one is from one of the countries listed on this travel ban, it is important to consult with an immigration attorney to determine how this travel ban may affect your case or how it may affect you in your future if you're seeking to apply for an immigration benefit. So this travel ban, as I said, depending on the country, some of these have full entry restrictions and others have this partial restriction. Now, the travel ban does have some exceptions, and this includes lawful permanent residents, also existing visa holders, certain visa categories, and for example, this would be athletes or diplomats, and individuals who enter whose entry serves U.S. national interests. So again, certain countries, we are looking at some restrictions that are going to prevent individuals at this time for entering the United States. Again, kind of depends what country you are from, and that will determine whether or not this travel ban will affect your case. Now, that's one of the immigration policies that we have seen changed. Another policy that we have seen changed is the immigration bond. So generally, the way an immigration bond works is if an individual is detained, ICE will look at the case and determine whether to set a bond for this individual or release them on their own recognizance. Well, things have shifted and changed, and so now we're not really seeing ICE issuing as many bonds as they used to. And so what that means is if there's no bond issued by ICE, the individual has to go to an immigration court to seek a bond and ask the judge to release them on bond if it can be shown or established that this person is not a flight risk or a threat to the community. Now, there was a decision that came out of the Board of Immigration Appeals a few months ago, and it basically made it harder for individuals who entered into the United States without authorization. Doesn't matter if it was maybe a few weeks ago or this year or 20 years ago. Basically, that decision limited the individuals who are eligible for a bond, and the decision basically said anybody who's entered without authorization is ineligible for a bond. So what we have traditionally seen in the immigration field of either ICE officers or the immigration judges making a determination on bond, we have seen that basically taken away, where the judges have said now said, if you enter without authorization, we do not have the jurisdiction for to grant you a bond. And so what we have seen now is individuals have had to go to a district court to file a habeas corpus petition seeking either release or seeking that the court find that the immigration judge, which is again part of the Department of Justice, has the authority to consider a bond. Well, I want to say a couple of weeks ago, there was a decision that came out, and this is under Maldonado Bautista. And this decision basically says that certain class members under this case are eligible for a bond if they entered without authorization. Now, there are certain other requirements besides just entering without authorization, but if you fit under this class membership, then you should be eligible to seek a bond with an immigration judge. Now, that's easier said than done because, again, we are seeing conflicting situations or conflicting decisions all across the nation in terms of, are judges actually following this decision or not? Or do we have to go back to a district court to file a habeas corpus petition to try to seek release? So immigration bonds are something that has really changed this year with the administration and the policy changes and the decisions coming out of the Board of Immigration Appeals. If you have a loved one who is detained, it is important, and I know I say this often, but it is important to consult with an immigration attorney because not every case is the same. We have had situations where individuals have told us, well, we've seen this, we've seen a group of people being released from a detention center. Why can I not be released? Or am I also eligible? So just because someone is released from an immigration detention center or was granted a bond doesn't necessarily mean that everybody in that detention center is going to be granted a bond. And this is why it's important for us to look at the case because oftentimes it's a case-by-case situation. Now, another big policy change that we've seen is with USCIS. USCIS, again, is U.S. Citizenship and Immigration Services. This agency is the one that oversees residency cases. They oversee citizenship cases. They also oversee other immigration benefits, such as temporary protected status, DACA. So this happened early in December. I would say December 2nd, USCIS announced a policy change stating that they were basically placing an indefinite hold on all asylum applications. Doesn't matter what country that person is from, they are holding those cases indefinitely. Now, I know a lot of people are worried about this situation, especially if you have an asylum case pending. This is with USCIS. If your case is in immigration court, which is not part of USCIS, it's part of the Department of Justice, well, the immigration judges are still hearing those cases. So from what we've learned with USCIS holding these asylum cases indefinitely, they are still conducting interviews, but they're not making any decisions yet on these asylum applications. So what we are likely going to see is backlogs, and again, just waiting to see what the government ends up doing, or USCIS, with these cases. Now, with that policy change that was announced, they also said that they are placing an indefinite hold on all benefit requests made by individuals that are on the 2025 travel ban. And so this, again, is making it difficult for individuals from certain countries where we've seen situations where the person was already scheduled for their residency application or their citizenship application. And unfortunately, those interviews have been canceled because of this policy change. The other thing that the USCIS mentioned was that USCIS is required to re-review the benefits that were requested and already approved by certain individuals from countries named in that 2025 travel ban. And if they entered in the into the U.S. on or after January 20th, 2021. So USCIS is not only holding certain cases or pausing them indefinitely, but certain individuals who have already received, let's say, their residency or their approval on their asylum based on these requirements, it could be that USCIS is going to re-review that case to make the determination of whether it was that individual should have been granted that benefit or not. So I know these are very uncertain times for a lot of people, and a lot of people are nervous. And that's why it's extremely important to talk to an immigration attorney to see how these policy changes can affect someone. And what happens with policy changes oftentimes is there may be a policy change, there may be a lawsuit. So in these situations, sometimes we could say, well, yes, right now you qualify for this, but then something changes in the future and then there's another lawsuit. So oftentimes we do see a lot of just uncertainty where we have to see what the government is trying to change or what is that policy change. Is there going to be a lawsuit to determine, okay, well, this is what, this is the situation in your case. Another question that we have received is what happens if my immigration benefit is denied now? So sometimes when an immigration benefit is denied, the agency will let you know your case is denied and nothing really happens. But right now, what we are seeing, again, because of policy changes this year, is that if your case is denied, and this denial we're talking about with USCIS, that specific agency, well, in that situation, what we're seeing now is that the agency is sending out notice to appears. And a notice to appear basically means that the government believes that you are not a citizen of this country, that you are removable based on certain reasons. Oftentimes it could be, well, this person overstayed, or this person was never admitted or paroled into the admitted, inspected, or paroled into the United States. And so if you are planning on applying for a benefit with USCIS, one, you want to make sure, do you actually qualify for that benefit? Are there any risks to applying for that benefit? Because again, if there is a denial, it can lead to the person being placed in removal proceedings. And when someone is placed in removal proceedings, basically the government is saying you're going to have to go to an immigration court and you're going to have to present your case as to whether you qualify for a benefit or not. And if you don't qualify for a benefit, unfortunately, oftentimes the only two options would be voluntary departure or a removal order. So very important to be aware that if you do have a case pending or you're thinking about filing, seek that guidance and see if you actually qualify for this benefit and what the risks are associated with applying for that benefit. Now, if your immigration benefit is denied, for example, in immigration court, in that situation, oftentimes you have the right to reserve an appeal. And so what that means is that you think that decision that the immigration judge issued was incorrect, and so you would like to appeal that decision and take it to a higher court, which would then be the Board of Immigration Appeals. So depending where your case is, in terms of which agency is reviewing it, will make the determination of how you can move forward or what will happen if that case is denied. Now, immigration is a really big field. We deal with a lot of separate agencies. So this is these two agencies that I've mentioned, which is the Immigration Court, which is part of the Department of Justice, and USCIS, Citizenship and Immigration Services. Those agencies deal with individuals who are here in the United States. If you have a case outside the United States, that's generally when you're dealing with a non-immigrant visa case or an immigrant visa case, which is residency, and that would be with the Department of State, and that would be with the U.S. Embassy or U.S. Consulate, where the individual goes to their interview. So oftentimes immigration cases can get confusing because you are sometimes dealing with more than one agency throughout your case. But right now we're strictly talking about the agencies that are here in the U.S. Now, another question that we have gotten a lot is, will I be detained at my interview or ICE check in? And there, and I imagine many of you have seen through social media and through the news, they are detaining individuals. Not everybody's being detained, and we are seeing that in um, some cities, more people are getting detained compared to other cities. So, for example, here at the local USCIS office, we're not seeing as many people getting detained as individuals who are going to their USCIS interviews in Miami and San Diego. So, it kind of depends on where your case is located. But in there are situations where individuals are getting detained, but there are situations where we've gone to our interviews and clients are not getting detained. And so what we're doing is we're just having these conversations with our clients, also explaining to them the potential of you could potentially get detained and what that would look like if the person does get detained. And the biggest thing that you can do, especially if you're seeking an immigration benefit and you have an interview coming up, is be prepared. If there is that risk of getting detained, what are going to be my next steps? Am I going to be eligible for a bond if I get detained? If I'm not eligible for a bond and I get placed in a detention center, am I going to be able to fight my case in immigration court? So these are all things that individuals need to think about while going through the immigration process. And not only think about that immigration part, but also if you have, say children here, or your spouse, maybe the U.S. citizen or lawful permanent resident, isn't employed, or their responsibilities are household responsibilities and taking care of the kids, and maybe they don't have access to that bank account, or they don't have the knowledge of what all bills are getting paid, or what are all the financial responsibilities. These are conversations that you have to have, again, because what you want to do is you want to be prepared and have a plan in case you are detained, not only through the immigration part of, can I present my case in immigration court? Will I be okay fighting my case while detained, or can I seek that bond? But also, what's going to happen in my family? What's going to happen to my kids? Who's going to be responsible while I'm fighting my case to get out on bond, or fight my case before the immigration court to try to seek this benefit? Now, will someone be detained at their ICE check-in? This is a really hard question to answer, because the likelihood is that, yes, if you have to check in with ICE, there is that very realistic chance that you're going to get detained. We have seen situations where individuals have not been detained, but we have seen more individuals lately get detained. And again, this is extremely important to know, because we have consulted with individuals who want to do the right thing. They've been reporting with ICE every year while their case has been pending. And again, because of policy changes, we're seeing individuals who haven't had issues with the law are checking in, but they are getting detained. And we just want to be, have that conversation with the individual and let them know, if you do, if you do go to that ICE check-in, there is that likelihood that you're going to get detained. So again, are you prepared if you do get detained? Because again, if you have children, if you have a spouse, if you have property here, if you have car payments, etc., you want to make sure that everything is organized and you have a plan. You have someone who is going to be responsible and be able to, my recommendation is getting a power of attorney with someone. Give that power of attorney to someone that you really trust, who will be able to take care of your affairs if you are to be detained. Now, if you do not show up to your ICE check-in, just know that ICE potentially could go look for you. Now, it could be days, it could be weeks, it could be years. Again, we we don't know. They're the ones who would make that determination. But if you don't show up, there is that potential. Eventually, they could detain you. Also, if you, get pulled over, get transferred over to ICE, they could see that, you were supposed to check in. And at that point, it could be a little bit harder to get that immigration bond potentially. But these are all conversations that are hard conversations, but these are conversations that you need to have with your loved ones because, again, being prepared is going to be really important in these situations. And I say this because we've had consultations with individuals who unfortunately have been detained, whether at their interview, at an ICE check-in, and the children don't have passports to travel outside the United States, or, they don't have a family member, power of attorney for someone who can move around, go to their bank and get some money, or, someone who needs to sell their vehicle. And these are real life examples that are happening now. And so that's why it's very important to be prepared and have that plan. Now, another question that we get that we've been asked is, what rights do I have if ICE detains me? Well, one, you do have to identify yourself. So one of the things is, if you are going to be detained by ICE, please do not give a false name. Do not present false information. You will get in much bigger trouble in that situation. But if you get detained by ICE, you do have rights. And you have the right to ask for an immigration judge. Now, depending your situation, there can be a situation where you no longer have the right to see an immigration judge. And this is where we see this where the person already has a removal order. And let's say someone had a removal order from 15 years ago, just never left. ICE does a immigration raid or stops them, picks them up. In that situation, ICE has the right to execute that removal order from 15 years ago. Now, sometimes we can try to obtain what's called a stay of, or apply for what's called a stay of removal with ICE officers. This is not a permanent solution, and generally they want to say they want to know why we're seeking the stay of removal. How long is this person trying to stay here with the stay of removal? So if you have a removal order and you do get detained by ICE, that is going to be a more complicated situation because, again, they have that right to execute that removal order. Now, if certain things have changed in your country, or you have a fear of returning to your country, then that may be a situation where we may try to seek asylum, again, just depending on the situation and the case. But that unfortunately doesn't apply to everyone. If you have no removal order, then generally you do have that right to see an immigration judge. Now, if you entered into the United States under a visa waiver program, that you do not have you do not have the right to see that immigration judge. So depending, again, immigration, it's not one size fits all. We always have to know the details and the situation to analyze that case and see if that person can, in fact, see that immigration judge, or can that person be released? Does that person qualify for an immigration benefit? But you do have rights when you do get detained by ICE. So like I said, most of the times you should be able to say, I want to see an immigration judge, outside of the few exceptions. You have the right to remain silent. So you do have to identify yourself in terms of, my name is so-and-so. But if they ask you, where were you born? What is your citizenship status? At that point, you can exercise your right to remain silent. You don't have to sign anything, especially if you don't understand it, or let's say your loved one is detained and they don't know how to read in English. Well, it's better for them not to sign something, because if you don't know what you're signing, you shouldn't sign it. And you have the right not to sign. Now, one of the things that sometimes people ask is, well, my loved one already has a removal order that was issued to them 5 years ago. But if they get detained now, as long as they don't sign, they're not going to get removed, right? Well, no. again, immigration, because they have that outstanding, they have that removal order, ICE has the authority to reinstate that removal order or remove the person. So if you have a loved one who has a removal order, very important to see if there's any way to potentially maybe reopen the case, or see if that person qualifies for an immigration benefit. But it's always important to remember that if you do have any interaction with ICE, you do have the right to remain silent. You can ask them. You can say, I don't want to say anything until I speak to my attorney. And you should also have a point of contact, whether it's a relative or a best friend, who has an immigration attorney's phone number. So if you are detained, you can call that relative or that friend, let them know that you're being detained by ICE, and then they can communicate with us, the immigration attorneys, and we can see what it is that we can do in that situation. Now, another question that I have is, can I lose my citizenship or permanent residency? This is a big question that we've had recently with a lot of individuals based on what's being presented in the media or social media. And a lot of people are scared of losing their citizenship or also their residency. And we have seen, and speaking, I know earlier I was talking about immigration policies. We are aware that it's been announced that the administration wants to look at citizenship cases to see if more citizenship cases to see if certain individuals need to be placed in a denaturalization process. If you are a U.S. citizen, as long as, everything was in order, you obtained it legally, there was no sort of fraud, there shouldn't be a reason why you would lose your citizenship. But I get it, and I know people are scared. I know there's a lot of discussion in terms of citizenship, birthright citizenship, the administration wanting to do denaturalization. And I know it can be daunting, but, we have to take it one step at a time. If you were to find yourself in that situation where the government is trying to proceed with denaturalization, you still have rights. It doesn't mean that it is going to get taken away. You have the right to see what it is that the government, why they want to denaturalize you. And you have the right to fight that case. So even though we are seeing, a lot in the news about getting citizenship potentially getting taken away through denaturalization, or, if they were to end birthright citizenship, it is very scary and frightening for a lot of people. But again, there are certain rights and there are ways to try to fight your case, again, depending on the situation. But what I say is try to have some hope. If you find yourself in a situation where, they're looking to detain your loved one or deny the benefit, there are ways, look at it. What is it that the government is alleging? Is there a way to appeal the case or fight the case? Okay, so I know, again, this is very stressful for a lot of individuals, and us immigration attorneys, we're here trying to, trying to make sure that you understand and are aware of policy changes and, how that can affect you, but also what it is that you can do. How can you protect yourself, or how can you prepare and plan for the worst case scenario? Now, another question is, does a denial of asylum or other benefit automatically lead to deportation? So, I will say generally no. And so a lot of people, what they think is if your case gets denied, automatically you're going to get taken and they're going to remove you from the country. Now, I know things have been a little bit different under this administration, that we've seen things that we normally don't see, but generally, no. Just because you have a denial doesn't necessarily mean that, they're going to knock on your door right now, or in immigration court, they're going to take you and remove you. I had a trial earlier this week. We presented ourselves with our client, did our trial, ended, and, we walked out of the court. Now, I know that we have seen detainments in immigration court, and these we've usually seen not at the trial level, but generally where the person has filed or is about to file, for example, their asylum case. So, to that question, generally, no, you're not going to immediately be removed or taken away right then and there. We are seeing some situations, like I said, that we had not seen before with other administrations. But again, if you do get detained, if you get placed in a detention center, depending on your situation, you may still be able to fight for your case or apply for that immigration benefit or continue with that benefit while detained, or seeing if we can get a bond, get the person out on bond. But most of the times you're not going to just get your case denied and you're immediately taken out of the country. And the other thing is, remember, immigration, it's a really big field. Some people have their cases in immigration court. Other individuals have, for example, their asylum or residency case with U.S. Citizenship and Immigration Services. So these are all different agencies. And so depending on where the case is, depending on your situation, most of the times you're not just going to get picked up and taken after a denial. And, even in immigration court, if you get a case denied, you can still appeal the decision. With USCIS, if you get a denial, sometimes if it's an asylum case, you'll get referred over to immigration court, or let's say it's a residency case with USCIS and you get denied. Depending certain situations or citizenship, you might be able to appeal that case, or as I mentioned earlier, you may get a notice to appear, depending on the case and situation, and at that point, fight your case in immigration court. Now, are work permits still being processed or extended? So yes, work permits are still being processed. Immigration, this would be the Department of Homeland Security, USCIS, U.S. Citizenship and Immigration Services, they are still processing and approving these work permits. Now, what unfortunately has happened is that they've removed the automatic extension for these certain categories that used to qualify for an extension. And so if you are someone who has to renew your work permit, you want to make sure that you're renewing it on time, because one, even though they are processing work permits, sometimes we are seeing certain delays for certain cases. And so you don't want to lapse between the current work permit and the new work permit. So you don't want your work permit to expire and you be out of status while you're waiting for your new work permit to arrive. So yes, they're being processed. Unfortunately, the extensions are no more. But again, stay on top of your benefit. When is your expiration date? You want to make sure you have that on your calendar. You want to make sure that you are filing on time. Another question: if I received a request for evidence, what should I do? So request for evidence is where we see it with U.S. This we see with U.S. Citizenship and Immigration Services. And oftentimes we'll see this when someone has applied for an immigration benefit by themselves, which is pro se, or sometimes even through an immigration attorney. Sometimes we receive these RFEs. Sometimes we've already submitted the evidence with the initial information or packet, and somehow it got lost in the mailroom, and so they're asking us to resubmit something that may have been lost when they received it, or did not get scanned through properly when they received the document. Another one could be because, maybe you were arrested and you got the dismissal, but you put that you were arrested, but you didn't actually submit that criminal document. And so now they need to look at it to verify and make sure that they have the documents that are necessary to make the decision. And other times it could be that someone just didn't know that they had to submit a particular document with that case. So if you receive an RFE, a request for further evidence, you want to make sure and read it completely, read it thoroughly, understand what it is that they're asking for, and also look at the deadline. if you miss that deadline, your case is gonna get denied for failing to submit it within that timely manner. So it's very important if you do receive an RFE that you understand what it is that they're asking for. Even if you already submitted it previously, go ahead and submit it again. Like I said, there have been situations where we've submitted documentation, we have our scanned copy and we know we submitted it, but they're asking for it again. So even though you've already submitted it, resubmit it again. Don't just write a letter saying, I've already submitted this. Submit what they're asking. All right. So other questions. How are changes affecting family-based petitions? And this is like marriage or visas for relatives. So one, as I mentioned earlier, we've seen an extension of the travel ban. So this is affecting certain family-based petitions, people that are abroad that are not right now going to be eligible to enter the United States. So we are seeing that in certain situations right now, families are in limbo in terms of, can they proceed with their immigration benefit, or what's going to happen to their case that's currently pending right now. So we've seen a lot of families who are in limbo, and we've seen a lot of uncertainty at this time. Now, individuals who are here in the U.S., we're still seeing people here and abroad applying for immigration benefits. Those that are not subject to the travel ban, generally cases are still being processed within those normal processing times. But we are seeing certain changes. We are seeing a lot more people, really thinking of, do I want to apply for an immigration benefit right now, or should I go ahead and apply for it now? And we are seeing other individuals who are, maybe have been in a common law marriage for maybe 10 years. And now they're like, you know what? I want to make sure that my loved one is here with me. Let's move forward, because we have seen situations where someone, they love each other, they qualify for residency, but times just passed and kind of put it in the back burner. And now with the way that things are changing and policies are changing, we are also seeing people saying, you know what, I want to go ahead and move forward with my case in case something else changes and I'm no longer eligible for this benefit. So we've seen from one side uncertainty and delays, and from from the other side, we are seeing more other individuals saying, I want to move forward. I want to make sure that my loved one has their immigration status here. So another question that we have been getting is it safe to travel outside the U.S. while my status is pending? And we've had a lot of individuals contacting us for this, asking us this in the last few weeks. And we know that a lot of individuals like to travel outside the United States for the holidays, go visit family outside. And so we've had lawful permanent residents who have been contacting us, who are scared to travel outside the U.S. because they're terrified that they are not going to be eligible to come back into the U.S. So if you're a lawful permanent resident, generally you should not have any issues traveling outside the U.S. and coming back. But there are certain situations where, as a lawful permanent resident, that can affect you. One, if you have certain criminal offenses. So if you're a lawful permanent resident and you have been convicted, arrested for a crime, consult with an immigration attorney. Even if that offense happened 20 years ago, we see it often where someone, is a lawful permanent resident, has been able to travel outside the United States back and forth for many years. And then the individual re-enters the U.S. after a vacation or time outside visiting family. They come back and the officer starts asking questions because they're able to see that this person was convicted of a crime, let's say in this example 10 years ago, and that person didn't know that that was a deportable offense, and now that person is being placed in removal proceedings where the government is alleging that the person is deportable even though they're a lawful permanent resident. So this is a situation that we have seen. So if you are a lawful permanent resident, it is important to consult with an immigration attorney if you have been arrested in the past, because there are certain criminal offenses that could make you deportable. Doesn't matter if you traveled outside several times, multiple times throughout the years. It just takes that one entry where you can get detained and get placed in removal proceedings. Another situation where we've seen lawful permanent residents potentially, getting placed in removal proceedings or signing to abandon their residency is individuals who have been outside the United States. As a lawful permanent resident, you have the authorization to travel outside the United States. But when you're a resident, you're saying that you're living here in the U.S., your residence is here, your work is here. And so if you are using your residency more as a tourist visa and not as an actual lawful permanent resident, let's say you're actually living abroad and just coming here temporarily, well, at that point, yes, you traveling outside the U.S. and then trying to re-enter, you could find yourself in a situation where the government is alleging that you have abandoned, or they believe that you've abandoned your residency due to your time outside the United States. One of the things that I will say is if you want to travel outside the U.S. and you're worried, consult with an immigration attorney, and we can let you know what the risks are if you do travel, or if there is no risk at all for you traveling. And the other question that we've gotten in terms of travel are individuals who are here who want to travel from one state to the other and maybe don't have status. In that situation right now, we are advising that is a bit trickier, because you could get potentially detained. We've seen situations where a group of individuals were taking a road trip and they got stopped and detained by the police for something as simple as a speeding ticket, and then getting transferred over to ICE. Individuals who have traveled by train, bus, or airplane who have gotten detained. Now, I'm not saying that everybody is getting detained, but there have been situations. And so if you are planning or thinking about traveling, just assess the situation and, do what's right for you. But, just be aware that there could be a situation if you're undocumented and you're planning to travel to another state, planning to fly from one state to another, that there is that risk of potentially getting detained. So those are all the questions that I received. I know we've gone through a lot, and I know with immigration law right now, as I mentioned earlier, there's a lot of uncertainty, but people are still filing applications. People are still eligible for benefits. I know it can seem very worrying at this time, but this is why we're here as immigration attorneys, to let you guys know what the laws are, what the policy changes are, how that can affect you, the risks associated with applying for some sort of immigration benefit, determine if you actually qualify for an immigration benefit, and then let you all make that decision. If you guys have any questions and would like to consult with our office, you can always call us at 972-827-8359. Thank you.